I'm Mark Nelson. I'm one of the writer-analysts with the Wolters Kluwer Law and Business Federal Securities Group. This is the third installment in a four-part video series on the recent SEC proposed regulation crowdfunding. It's based largely on a webinar I conducted back in mid-December on the same proposal. Today's topic will be the issue of issuer compliance under proposed regulation crowdfunding. It raises some interesting potential for issues here, especially with what I think is intended to be an easier burden to file and comply than would perhaps be the case with some other exempt securities offering alternatives that are currently available to issuers. And so we'll get right to the start here. The main disclosure that an issuer needs to make under proposed regulation crowdfunding is to be made on a new form called Form C for crowdfunding. This would entail disclosing some details about the business, about some personal details about the issuer and its executives and managers, also some details about the offering and some basic information regarding the issuer's financial and tax aspects. It's interesting to note that an issuer here would be required to file certain progress reports when they hit the 50% and 100% milestones of their target offering amount. These updates would be filed on a new Form C-U. Any updates would need to be filed on this form within 5 business days. Also, any material amendments to Form C must be filed on a new Form C-A. It's important to note with respect to Form C-A that in the case of material amendments, the issuer must check a box on that form telling investors in the crowdfunding offering to reconfirm their investment commitments. Otherwise, the investor's investment commitments will be withdrawn. However, there is no similar requirement to check that box for non-material updates. With respect to periodic reports, there are several that a crowdfunding issuer would be required to file. One would be the annual report on Form C-AR. This would be filed within 120 days of the issuer's fiscal year end. Also, it's important to note when an issuer's reporting obligations under proposed regulation crowdfunding would end. Typically, this will happen when the crowdfunding issuer becomes a reporting company under the Exchange Act. It could also happen if the issuer or another party were to purchase all of the securities that had been offered in a crowdfunding offering by this issuer, or the issuer in the crowdfunding offering were to dissolve under state law. In this case, whatever the reason for terminating their reporting obligations under the proposed crowdfund regulation, the proposal would have the issuer file an update on Form C-TR for termination of their reporting obligations. Some other topics that are important to crowdfund issuers, I think, would be the advertising rules, promoter compensation, and also the disqualifications for issuers under the proposal. With respect to advertising, a crowdfunding issuer is prohibited from making any kind of direct ads about the terms of an offering. But the issuer would be able to communicate with investors on communication channels provided via a crowdfunding intermediary's platform. Also, an issuer could direct investors to an intermediary's crowdfunding platform by way of tombstone-like ads that just state some basic information about the offering and how to contact the intermediary's platform. These would be very similar, says the proposal, to existing tombstone ads allowed under Securities Act Rule 134. Also, with respect to payments to promoters to advertise crowdfunding offerings, in general, an issuer can pay a promoter who uses an intermediary's platform to promote an offering, but the issuer must take some reasonable steps to ensure that the promoter discloses any past or prospective payments in this regard. The same rule would apply for the issuer's founder or its employees appearing in comments or commentary on the intermediary's platform. Also, an intermediary, and we'll talk about this more in the final installments to this video series, but an intermediary at the account opening stage must make certain disclosures about promoter compensation. With respect to the disqualifications for crowdfunding issuers, these largely track those of the more recent Regulation D bad actor disqualifications, which were created in the wake of the Dodd-Frank Act. The Jobs Act also requires that the crowdfunding exemption can be lost through disqualification. It's interesting to point out that these exemptions, these disqualifications for crowdfunding issuers would apply quite widely. And I'll just look at my notes here briefly. They would apply to the issuer, to the issuer's predecessor, affiliates, directors, officers, general partners, managing members, and I think more significantly, 20% beneficial owners. Especially the beneficial ownership issue, that's something that I think a lot of people might want to look more closely at in proposed regulation crowdfunding. Also, another interesting tie-in here with the SEC's recently proposed Regulation A+. Reg A+ is something that has been talked of in prior years, but with the enactment of the Jobs Act in April of 2012, the requirement under Title IV for the SEC to move forward with that modified Regulation A became imperative, and they have now, as of mid-December, made that proposal. An interesting tie-in here is that the proposed Regulation A+ would actually make some significant revisions to the bad actor disqualifications in Rule 262. This is important because both the Dodd-Frank Act bad actor requirements, on which the crowdfunding disqualifications are largely based, are all rooted in the Regulation A Rule 262 requirements. I think the purpose here, according to the Reg A+ proposal, is to achieve some greater uniformity in the issuer disqualifications across the range of exempt offering alternatives under the Securities Act. And that brings us to the close of today's topic, which was issuer compliance with proposed regulation crowdfunding. I look forward to talking to you again in the next video about crowdfunding intermediaries and a new type of entity called the funding portal. Until then, I'm Mark Nelson for Wolters Kluwer Law and Business.